Good morning, good afternoon, and good evening. Welcome to Course 5B of the Monique and Roland Bale People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy. Our topic for today is individual and collective human rights and challenges to their realization. Our faculty for this course includes Chief Charles Taku, Roberto Zamora, and Martha Schmidt. Each of them will speak for about 35 or 40 minutes. Then they will comment on each other's presentations, followed by questions and answers from the registrants. We have French, Spanish, and English interpretation. Please, and if you want to activate that, there's a box that says interpretation at the bottom of your screen. Please put your questions in the Q&A box for our discussion later. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. Although we generally think of human rights as individual rights, there are also collective human rights, including the right to self-determination, the right to a clean and healthy environment, the right to cultural, political, and economic development, the right to form and join unions, bargain collectively, and conduct strikes, and the right to peace. The International Court of Justice just completed 2 weeks of arguments by more than 100 states and organizations about the obligations of states under international law to protect the climate system and the legal consequences for states that cause significant harm to present and future generations. The overwhelming majority of states, primarily from the global south, argued that the right to a clean, healthy, and sustainable environment applies to climate change, and that the largest emitters of greenhouse gases are violating the right of the people to self-determination in states that are seriously harmed by climate change. One of the states that addressed the International Court of Justice was the Gambia, whose representative explained that the African Charter on Human and People's Rights treats individual and collective human rights as integrated. And I believe that Chief Taku will touch on this in his presentation. The International Covenant on Civil and Political Rights says that ethnic, linguistic, or religious minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. This course will enhance knowledge of international individual and collective human rights as developed through the United Nations system. It will examine the challenges to the realization of effective remedies to redress and prevent violations of these rights. Our faculty for today's course includes leading international human rights lawyers from 3 continents. Chief Charles Taku is an international legal practitioner before international courts and tribunals with 4 decades of professional experience, 25 of them in practice before international courts and tribunals, international adjudicatory bodies, international dispute settlement mechanisms, counseling, diplomatic practice, and conflict resolution. He is a cultural leader, a mentor, and a leading crusader for reparations justice for colonial crimes and historical wrongs. Chief Taku is former president of the International Criminal Court Bar Association and a life member of the governing council of the African Bar Association. He has defended cases in the International Criminal Court, the Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, the African Court for Human and People's Rights, the UN Human Rights Council, and national jurisdictions in Africa and Europe. He recently presented public lectures at the Sierra Leone Law School, Pantheon Law School in Paris, the Africa Development Conference at Harvard Law School, and the Kwame Nkrumah University College of Science and Technology in Kumasi, Ghana. Chief Taku will address individual and collective rights through the context of the progressive nature of the UN Charter and other treaties, including the African Charter and Human and People's Rights. Roberto Zamora is a human rights lawyer in Costa Rica. In 2003, as a third-year law student, Roberto filed a legal challenge to Costa Rica's support of the US-UK-led aggression against Iraq. The Constitutional Chamber of the Costa Rican Supreme Court ruled the support unconstitutional in violation of the value of peace, the Costa Rican Neutrality Declaration, and the UN Charter. The court ordered the withdrawal of Costa Rica from the so-called Coalition of the Willing. Roberto also filed a legal challenge to the president's decision to allow the manufacture of nuclear fuel and nuclear reactors for all purposes in Costa Rica. The Supreme Court annulled the president's decision as violative of the right to peace and the right to a healthy environment. With this ruling, the court recognized the right to peace as a human right of international dimension. Roberto also convinced the court to forbid the use of legally forbidden military weapons against civilians by the police. In 2018, Roberto won the case that overturned the ban on same-sex marriage in Costa Rica. Roberto will discuss political obstacles to the enforcement of individual and collective human rights. Martha Schmidt is a member of the task force of the People's Academy of International Law. She has an LLM in Law and Marine Affairs and a JD and Masters of International Administration. She co-chaired the Human Rights Framework Project of the National Lawyers Guild and was a board director of the Center for World Indigenous Studies. She advises national single-payer and other U.S. groups working on the human right to health. Marty has helped organize the movement for the human right to health care in the United States. She practiced labor and equal employment law in Washington State and chaired the World Peace Through Law section of the Washington State Bar Association, where she led a successful effort to get the association to support U.S. ratification of the Convention on the Rights of the Child. Marty served as regional vice president of the National Lawyers Guild and co-chaired its subcommittees on peace and disarmament, the occupied Hawaiian Kingdom, and the Task Force on the Americas. She has taught human rights, public international law, and the sociology of social movements at the University of Washington and Evergreen State College. Marty will focus on the popular conception of human rights through the lens of political economy. So we will begin our presentation with Chief Taku. Chief?
Thank you very much, Professor. Thank you very much, Professor, and welcome to every person who is participating in this course. I begin my presentation by raising the following questions that I've asked and asked in every conference. when we talk about international law, international human rights law, the question often asked is whose international human rights are we talking about? And I say so because, in my estimation, the rules-based world that was established at the end of the Second World War seems to have failed the world, in particular Africa and other countries of the world. But let me begin by citing my good friend, Professor Max Hilaire. Max Hilaire is a professor of international law. He wrote a book in which he stated, and I quote, "The Westphalia system was a state-centric order with limited recognition of individuals as having rights separate and dependent from their states. How individuals and how states treated nationals was an internal affair. We know the Westphalia order came from the Peace of Westphalia that ended 30 years war, 80 years war in Europe. Westphalia recognized limited human rights for individuals, the right of self-determination, protection of minority religions and diplomatic immunities for organs and personnel of the state. Given the origin of the Westphalia Order, which came at the end of a long war, it would be hard to have a lasting peace without a recognition and protection of the rights of the individuals. It did not extend similar rights and protections beyond Europe. I did not recognize non-Europeans who made up a majority of the world. Outside Europe, territories and people had no rights, were not granted protections under international law. They were considered uncivilized, and their land was characterized as terra nullius. This allowed European states to expand and conquer territories in Africa, Asia, and the Americas with impunity. Westphalia international law gave European states unchecked impunity to colonize, enslave, and kill the native population of these territories. As an intergenerational victim of colonialism, it would be a significant failure on my part to present this lecture without citing that the Westphalia legal order was the source of the partition of Africa. Indeed, the General Act of the Berlin Conference, which was signed on the 26th February 1885 by 19 European powers in Berlin, Article 6 of the said General Act stated that the colonial order, colonialism, aimed at bringing civilization to the colonized people. My maternal great-grandfather fought with the Germans for 9 years, and that explains my involvement in the reparation movement. If we look at the Charter of the United Nations, we will soon discover that the elements of the Westphalia Order written into the Charter. And that can explain why, in spite of the United Nations, in spite of the Charter, that committed to the protection of human rights and fundamental freedoms as a centerpiece of a new world order, colonialism continued. Africa and some people in Asia and other parts of the world were not subject of international law. They had no human rights. The United Nations in Article 1.3 was founded on faith in fundamental human rights, equality, the rule of law, social progress, cooperation between nations, big and small, in which human rights and fundamental freedoms will be encouraged and promoted without distinction as to race, sex, language, or religion. The UN Charter recognizes human rights, their promotion, protection, and realization as objectives of universal interest. The Charter, nevertheless, did not define human rights, did not define fundamental freedoms. From the perspective of the UN, all human rights are indivisible and independent. In this context, the Charter placed the responsibility on the General Assembly in Article 13b to initiate studies and make recommendations for promotion of international cooperation in economics, social, cultural, educational, health, and assisting the realization of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. The Charter, further by Article 55C, imposed a responsibility on the UN to promote universal respect for and observance of human rights and fundamental freedoms for all without any discriminative basis. And Article 62, Sub 2, created an ancillary organ, Economic and Social Council, ECOSOC, with a mandate to make recommendations for the purposes of promoting respect for observance of human rights, fundamental freedoms for all. It is interesting to note that the very first human rights convention that was established was a convention on the protection of humanity against genocide, 1948. And as we look at the world today, with the genocide, ongoing genocide in the territory of Palestine, we look at the genocide in Darfur, where I happen to be lead counsel, and we look at genocide in other parts of the world, and we look at the people who are responsible for this genocide and the impunity. We will ask ourselves whether that convention has actually realized its objective. The next convention may be called the Universal Declaration for Human Rights, 1948, is of extreme importance because it is one of the creations of the international community that has endured, that established standards, basic standards for the protection of individual collective rights. And it is one which is surviving. It was a major development in international law, even though it did not have a mechanism for enforcement. And when we look at the Universal Declaration for Human Rights and why it has not attained objectives, we moved into the 1950, the Korean War, and thereafter the Cold War. It ran into ideological landmines, I would say. The so-called allies who met from the First World War, they soon plunged the world into a type of unsafe environment. They made the United Nations and the United Nations human rights instruments. They incapacitated them, and they got them into some ideological fights that are ongoing. And they now defined from 1950, and thereafter when we had the United Nations, the International Covenant Civil and Political Rights subsequently, and the Covenant on the Economic, Social, Cultural Rights Then now the West decided to divide them, separate them along ideological lines. But that was not the objective of the United Nations Charter. That was not the objective of the Universal Declaration of Human Rights. And the African Charter on Human and People's Rights clearly rejected this dichotomy. And with your permission, let me read what the African Charter talks about this. The African Charter the African Charter clearly, just 1 minute, please. Let me get it. The African Charter, with your permission, let me read the preamble. It states, reaffirming the pledge they solemnly made in Article 2 of the said Charter to eradicate all forms of colonialism from Africa, to coordinate and intensify their cooperation and effort to achieve a better life for the purposes of Africa, and to promote international cooperation having due regard to the Charter of the United Nations and Universal Declaration of Human Rights, and that they rejected colonialism, rejected Zionism, and furthermore, conscious of their duty to achieve the total liberation of Africa, the peoples of which are still struggling for their dignity and genuine independence, undertaking to eliminate colonialism, neo-colonialism, apartheid, Zionism, and to dismantle aggressive foreign military bases and all forms of discrimination, particularly those based on race, ethnic group, color, sex, language, religion, or political opinion. The African Court for Human and People's Rights and the African Commission for Human Rights litigate cases of collective human rights and individual human rights without any distinction. In one of the recent cases, the case of the Southern Cameroons, Gwanguni versus Cameroon, the case came before the African Court, the African Commission for Human Rights. It was a case based on the collective right to language, to judicial system, to economic rights, and also the individual rights of the applicants who brought the case. On the African continent, we'll find this dichotomy, this division of the economic, social, cultural rights and civil and political rights to be mischievous, a mischievous attempt in order to use ideology in order to perpetuate colonialism or other forms of injustices. One of the collective rights of Africans and other states is the protection against the crime of aggression. And the crime of aggression is found in Article 2 and 39 of the United Nations Charter. But we've seen on the African continent that there are various acts committed by so-called superpowers against Africa and other nations outside the framework of the United Nations. The NATO bombardment of Libya, what we call the colonial treaties in Africa, the military bases in Africa, the environmental declarations, the mineral for weapons merchants that have devastated African resources. We also find that the collective right to self-determination that was first written into UN Charter, first to protect states. It came first from the Westphalia Order that I said to protect states, but which under the UN Charter, Article 76, was also intended to affirm the right to self-determination of colonized people, including the Southern Cameroon, the German colonies, and others, but also the right to self-determination of indigenous people, to education, to ancestral rights. And when I talk about ancestral rights, it's extremely important. That land belongs to people, some, many alive, some dead, and generation unborn. But to say that in Africa, many indigenous communities are deprived of their lands. The lands belong to the colonial settlers, and they now find themselves working as indented labor on their own ancestral lands. And many of these cases have gone before the African Court and some to African Commission. Of course, the multinationals, the activities of the multinational corporation on the continent. And also the new form of aggression, economic sanctions outside the sanction regime of the United Nations, the sanction under Article 6, Chapter 6 or Chapter 7 of the UN Charter, that has been used for 60 years against Cuba, of late against Venezuela, and used as weapons to topple progressive regimes and impose puppet regimes. And they attempt to remove regulations from actions that of individuals and predators that ruin the environment. Some of them that ruin the environment to conquer the world using technology, and also the right to international trade. Africans have gone to the Doha rounds in order to negotiate with the United States and other countries on the question of tariffs. But the former colonial powers, they use the tariffs to suffocate African economies while controlling the African monetary system. The franc zone, and of course, with their military might, the soldiers watch it. And this act of systemic injustices, which were legitimized by international law under colonial treaties, the systemic international order that has legitimized corruption under international treaties on African resources, international trade, fair balance of trade, has rendered Africa more vulnerable than was expected. Now, the question is, what are the remedies? We can observe that many countries, Africa and others, are moving away from the United Nations to other conflict resolution of mechanisms. Of late, you see like the Gambia taking the case against Myanmar to the International Court of Justice on the convention, interpretation of the convention against genocide. You see South Africa going to ICJ against Israel on the interpretation of the crime against genocide. We see many countries going to the ICC, International Criminal Court. And the reason that this occurs is because the United Nations has been hijacked. They have become a tool in the hands of the superpowers to perpetuate and justify and commit impunity. The rules-based world that the UN Charter intended to foster, to promote, and to protect the world from self-destruction have become a tool of destruction in the hands of a few of these superpowers. I've had a chance to litigate some of the cases, and the recent Assembly of State Parties of the International Criminal Court, I had the occasion to challenge France for the double standard it took when the ICC was intervening in African conflicts, African situations for the past 22 years of existence, and on the situation in the state of Palestine. This inability of some of the superpowers to be consistent, to respect the basic threshold and standard of the UN, non-discrimination, equality of nations big and small, and the basic tenets of international human rights, equality of all before the law, is not only sheer hypocrisy, but it makes them complicit in the crimes that have betrayed a sacred trust that was established in 1945. The collective rights of individuals under the concept, the state concept of self-determination, again has been abused when states turn and use the apparatus of the state to commit crimes against their citizens and people on their territories. That's an abuse. In South Africa, we had apartheid in South Africa, and we had unjust wars of attrition and destruction in many situations in Africa and other parts of the world. But it is a contradiction of the basic and fundamental notion of self-determination, which is an erga omnes obligation of states to protect the right of self-determination of their own people, of the indigenous people. Indeed, the African Commission on Human Rights in Ngumne and Cameroon held that the Southern Cameroonians were a people. They were a people subject to protection. They were people who had a right to self-determination under the UN Charter, under the international human rights regime, under the African Charter of Human and People's Rights, and under the International Covenant for Civil and Political Rights. When we talk about erga omnes obligations, like the prevention against genocide, the states have a right to protect the commission of genocide, perpetration of genocide against own people or against any people whatsoever. The right for human dignity, the human person, the Convention Against Torture. Indeed, the Convention on the Protection Against Genocide and the Convention Against Torture are extremely important to the extent that they have provisions by which, if there were a dispute involving interpretation of any of these treaties, after the procedural threshold has been met, the International Court of Justice will have jurisdiction in order to entertain the matter, like the South African case against Israel, the case of the Gambia against Myanmar. Also a matter of the question of collective rights. The Supreme Court of South Africa took a very important decision, even though in the Constitution, they did not have a justiciable right to have. But the Supreme Court of South Africa had during the HIV the HIV crisis, that the citizen had an enforceable right to be protected, to be provided retroviral drugs for victims. The right for the state to provide certain basic amenities, existential amenities like water, schools, education. The right to protect people from racism and racial discrimination. And this led the international community, as a matter of fact and a matter of law, to challenge the right of South Africa to establish Bantustans. Bantustans, which led finally to the collapse of apartheid. Of late, Germany admitted, they confessed to the racism of the Hottentots in Southwest Africa that Germany committed. Of course, that's just one out of many, many genocides that was committed against Africans, other people of the world during the racism and historical crimes. But Germany admitted that the people of Southwest, the victims, are now in court in Wickock with a collective claim for Germany to pay reparations for the crime of genocide that committed against the Hottentots. But the payment of reparations without an apology and the restitution of the human remains of Africans and people from other regions that are found in the museums in Europe. Some of the remains from my ancestral land found in research centers in Germany across the world. The collective harm that was caused by destroying the culture and the religion and the civilization of people, minorities, and other people, indigenous people, were white, for which are continuing crimes, are some of the crimes that were up to. Progressive lawyers were white must take up these causes because they involve, concern the very soul of humanity. I was completely overwhelmed when I went to Germany to see the property of my great-grandfather and see the museums. And I asked the director of the Ethnological Museum in Berlin, I came here, you showed a lot of respect for me. I almost laid out a protocol for me. But how do you think I feel when in the next room, you're showcasing my ancestral civilization, the remains of my ancestors and others, are prices of conquest of a savage people. So these are some of the problems that we are up to for the collective rights of a wide magnitude of people. The problem today, they see racism and also prejudice, but the problem is ideological. It's ideological. There are people like you and me and others who want just to be recognized as human beings to live on the face of the earth. That people who want to accumulate that look of us still as charter to conquer the world, both in space, by land, and in sea. The majority of the world is held captive. And that's why I started by asking the question that when we talk about international law, particularly international human rights law, whose international law is it? Who defines it? And that's why I've been involved, and invite one to involve in the struggle for the decolonization of international law. Because to some people, the international law is a balm. To others, it is a bane. To others, it is a bane. Who defines it? Whose international law? That is the question that, before I end this lecture, I will leave with you and everyone. If we have an answer to those questions, as a progressive lawyer, I believe that we'll have an answer. And the answer is that the international law should belong to the majority of the people. So international law, especially international human law, that asserts the humanity of every one of us and the right of us, of all of us, individually and collectively, to exist as human beings in peace, in dignity, and that the rule of law should be for everyone, because the international legal architecture, treaty architecture that was established in 1945 United Nations, the rules-based web, has failed, and has failed monumentally, because it's being used now to perpetrate injustice. You had the dean telling us about one of our participants, Roberto, the case he took against the so-called coalition of the willing, a group of states that operated outside the international treaty, multilateral treaty architecture of the United Nations to perpetrate crimes around the world. And therefore, with groups like that, with alliances like that, the world again is out on the course of self-destruction. And therefore, from an African perspective, the African Court of Human Rights would deem it necessary to start to establish what we call the Malabo Protocol. The Malabo Protocol to the African Court. It has criminalized more crimes than any other international treaty regime in the world, including environmental crimes, including mercenaries, including the international treaty regime that aims to recolonize Africa. The question of military bases on the continent, that was clearly outlawed. We have I had just written an article that has been accepted for publication by University of Pretoria Law Journal on the use of force, threat of use of force in the Sahel of Africa. But because the terrorism, the new definition of terrorism, what is the origin of terrorism? Who are the sponsors? The international migration, for which the stigma of migration, which clearly are helped by unjust economic practices, unjust sanctions, illegal sanctions outside the international treaty regime. Terrorism, the weapons. Africans do not produce weapons. So where do the weapons come? We have the international treaty for the proliferation of small weapons. The flow of finance to terrorist groups who control the monetary regime in Africa, especially in the Franc zone, from the French Treasury, and therefore who are responsible for terrorism to get Africa ungovernable so they can come in as saviors. And therefore, through the legal framework, the existing legal framework, we have been trying to seek remedy. I was one of the lawyers that took the case of Atemken, against the African Union to the African Court for Human and People's Rights in order to challenge the protocol to the court that limits access to the court by people on the continent of Africa. It says different African states must sign the protocol in order to allow individual mandates, citizens from their countries, to have access to the court. But many of these countries have not signed the protocol, keeping the majority of the people on the continent away from having an enforceable remedy to the violation of the individual and collective right before the African court. And I challenged this before the African Court for Human Rights. There was a split decision. I lost the case, but there was a split decision because that protocol to the African court violates Article 4 of the African Constitution, the Constitutional Act of the African Union that upholds the universal respect for human rights and access to justice for all Africans all on the continent. But again, it is a matter of politics, politicization of justice, ideological fist fights that are ongoing. I would have loved to say more, and I'm waiting under the control of the dean. If she feels that my time is coming to an end, she should let me know. But I talk about the question of the migration and the treatment given to migrant refugees. The 1951 Convention on Refugees and African Charter on Refugees clearly prohibits the refoulement of refugees back to countries where they fled, especially when their life will be endangered. But the politicization of migration in the United States and in Europe in particular, where deliberate policies by some countries of the European Union, Italy, France, and others, have killed thousands of Africans in the Mediterranean without any remedy, any recourse to justice. In other words, the European Charter protects Europeans and Europe. The International Criminal Court, where I'm a lead counsel, I've asked them to intervene because Italy, France, Greece, and other countries are members of the court and investigated crimes against humanity. So far, no action has been taken. But collectively and individually, these migrants are human beings. And some of the oldest conventions, like the European, like the convention, the Refugee Convention 1951 protects them. But they're being criminalized instead, if not massacred or killed by Spain and other countries in the European Union space. Petitions to the General Assembly and the UN Security Council, of course, nobody cares. They are preoccupied with attempts to reconquer the world or the competition on the Convention of Impunity, mass destruction, illegal coercive measures outside the multilateral treaty framework of the UN, of the United Nations Charter, and the raping of the economy of poorer nations, and the illegal arming of criminal gangs to topple and destabilize countries. In the case of Libya, the United States, France, and NATO, after the bombardment and the killing of Gaddafi outside the framework of the United Nations, under the so-called responsibility to protect mandate, they install criminal gangs, well-known criminals, terrorists, over part of Libya, which is a divided nation. And therefore, I ask the question, international law, international human rights, who defines it? They now defined these armed gangs and criminals as good rebels, liberators. And these are the people once in power in Libya who have enslaved African migrants. The practice of slavery of African migrants in Libya as human property and selling them. sex slaves, and all sorts of violations, and a conduit for proliferation of arms across the Mediterranean, across the desert, to Nigeria, to the Sahel, to Boko Haram, to destabilize the region so that the foreign petroleum companies, Shell, F, and others, can now, under the pretext of offering security against the criminal gangs, remain and loot the continent. In the Horn of Africa, the Horn of Africa is boiling. And within this, I gave an interview to a television in South Africa about the request of Israel to have a observer status in the African Union, and also the request, an attempt to set a military base in in the Horn of Africa against the African Charter. Of course, the application for observer status of the African Union was rejected. But the question is why? 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 Why even attempt to have observer status? What is the interest? So the Horn of Africa itself is totally in disarray. In the Great Lakes area of Africa, we have M23, Rwandan-supported military gang that's destabilizing the whole of the east of the Democratic Republic of Congo, the looting of minerals for coltan. In other regimes, the coltan that is used to make telephones in France, in Belgium, in the United States, in our regime, the coltan will be outlawed because they have a criminal origin, but they're sanitized. They're sanitized and become part of the capitalist economy. I was late counsel of the Special Court for Sierra Leone, where many of the people who defended the Revolutionary United Front of Sierra Leone, Charles Taku and others, they said that the war was committed in order to loot diamond. But this diamond was later on, the Coy blood diamond, was found in Antwerp. And throughout the years I was in the court, I never saw a single trader from Antwerp coming to court even as a witness. So once these resources are collected through criminal origin, they're sanitized in the world capitalist economy. That perpetuates indentured slavery and labor, giving arms in exchange for minerals and making the state ungovernable. They make the seas ungovernable. They have no access to the maritime economy, no access to ancestral lands. And in this situation, many of them are either forced into conflict or to flee. And when they come into Europe, they take the road, they are treated. I am not saying that migration per se is a good thing, but there should be due process of the law to process in all dignity the migrants, and to stop attacking their countries, crippling the economy. The Dean spoke today about the climate threat, that some are still in denial. Some are in denial. But the collective rights, as a matter of collective rights, that this number of countries, the African Union, now they went to the ICJ for an opinion. But again, it will still be resisted. So what we are doing by bringing these cases is not because we think that we are going to win, but because these are cases that at least are intended to calm the conscience of the world, to affirm the humanity in us. And we'll continue to use the available mechanisms, especially the ones that have not yet been hijacked, to use them in order to assert the collective and the individual rights of individuals. One of the basic collective rights in Africa is for Africans to control their own economies, to have their own currency. The currency of African state must not be in the French treasury. To bring an end to colonial treaties, where supposed independent countries are still paying the colonial tax to colonial masters, where the colonial masters are waging war and toppling regime and taking with the democratic process. So, what are the available mechanisms to counter this, to protect this right? The African human rights architecture has the highest number of human rights treaties on the continent in the world, but very few of them are active because of competing treaties, competing interests. The colonial treaties, multilateral and bilateral treaties, and the intercontinental treaties that were supposed to bind Africa together. But the African Court for Human Rights, up to this moment, out of 53 or 54 African countries, less than 26 are members of the courts. And among them, Rwanda, Benin Republic, and Tanzania withdrew the individual mandate, the ability of their citizens to go to the African court, to seek redress African courts. Left without any particular redress for their individual and collective rights, they resort to what called self-help. They take up arms. With regard to the ICC, I fought the ICC. I was the first person to make the case that the ICC was one of the treaties that African countries negotiated as subject international law. But for 22 years, they was active only in African situations, making people believe that it had become an instrument for recolonization of Africa. Not that I'm against the intervention in Africa when crimes are committed, but because the situations when they came to the continent, they did not get the right criminals, because the criminals, the people committing crimes in Africa, are not necessarily blacks, are not necessarily just African youths in the combat zones, but the multinational corporations and certain states outside the continent. The people supplying the weapons for the crimes to be committed, knowing that they will be used against Africa. But the fact is that the new prosecutor, Karim Khan, has looked elsewhere in Asia and other parts of the world. And for me, even were to end only with arrest warrants, if it were to end it today, I think it must not were to end, then the people for whom arrest warrant be issued are at least now known as indicted war criminals. They have that stigma. And that stigma itself is a serious rebuke. That goes beyond what the Security Council could ever have done. And that is a significant contribution to the international rule of law. Now, let me set my eyes a bit, with your permission, to talk a bit about indigenous rights, the right to identity, the right to self-determination. The indigenous people before the Berlin Conference were autonomous kingdom. I'm a cultural leader belonging to autonomous kingdom. The colonial states, and according to the new colonial states in Africa, cannot in any way impose another personality that robs me of my cultural rights, of the right as a human being, the right of dignity, the right to my religion, the right to language, and the right to civilization. They should protect them. They should protect them. But the case is that the new colonial architecture state architecture in the colonized states, the leaders in this country are still agents of neocolonialism. They're agents of neocolonialism. Hence, they turn the apparatus of the state in order to preempt the right of self-determination of indigenous people in their own homeland and their own communities. The notion of sovereignty has been turned upside down so that they use the sovereign apparatus of the state to commit genocide, to decimate the indigenous population, seize their lands, make them indentured laborers on their own property, turn their women into sex slaves, and indeed to perpetuate the culture of slavery, a new form of slavery. This time as proxies for the new colonial regime whose economic interests they are serving. And this is the battle which is ideological. As a lawyer appointed to the United Nations Charter, international multilateral treaty architecture, but at the same time, we must not forget that they don't operate in a vacuum. They operate in a well-infested ideological landmines that are leading the world towards self-destruction. At least a majority of the world has been pushed to levels of poverty unprecedented in the midst of plenty. They have no control over the air they breathe. Yet we have the convention, the Kyoto Protocol, and other conventions for the protection of the environment. Yet the ideological interpretation of these treaties. It's not the treaties themselves, the ideological interpretation we'll find ourselves. And that's why I said international law, as we have it, is a balm and a bane. It's a balm for some and a bane for others, but a bane for the majority of the world, including people like myself who are intergenerational victims of colonial or historical injustices. Among the poor people in the world, among the victims in the world, who are connected by a common thread of our resilience and determination to wage a progressive fight for the enthronement of international rule of law that recognizes the equality of all humans, that recognizes the humanity of all, that recognizes the prevention or the commission of genocide, hiding behind the state or interstate so-called state apparatus and right of self-determination. They turn it up on its head. That recognizes the willingness of the whole majority of the world to live in peace, and that the people can live off their environment, the lifeline, the ancestral lands, their civilizations, and that can assert the right for reparations and the repatriation of all the looted treasures, cultural heritage, and the human remains that are found in European possessions, some of which I've seen, and the repudiation of all colonial treaties, and the banning of all military bases on the African continent and elsewhere in the world, and the reconsideration of the politics on migration, the humanity to humanize human beings, migrants, the right of migrants, and for repudiation of unjust sanctions, which are used as a lethal tool of aggression. 60 years of economic blockade of a people who are only asserting the right to self-determination to exist as a people, and a right to justice and a fairer United Nations. We are certain that Africa needs at least 2 seats in the UN Security Council. We'll be advocating for that. And there's no reason why, since 1945, the very so-called superpower that failed the world, that led the world to another potentially third world war and self-destruction, they leave the fate of the world in their hands so that the world is being pushed to destruction on our watch. And that has erected a pillar of impunity, that there are certain persons who are untouchable in the world. They can commit all crimes, throw bombs on women and children on our own eye. Where is the conscience of the world? They will have children who are being born today. They need not go to the battlefront where they look at the television, everything, the bombardments. They grow up in the culture of violence. And therefore, the international treaty architecture, international human rights architecture, although was not defined in the UN Charter, the Universal Declaration of Human Rights took a step further, whereby our action and our resilience were giving context and content were given a human face to international human rights for the defense of our collective and individual rights, and that we're in the majority. And I call everybody listening that this is a matter of urgency, extreme urgency. It is not for some other people. With every passing day, politics have been transferred. People can now effectively, in the campaign for politics, clearly in different languages, they are campaigning in order to enthrone racism, and that nobody should talk about the historical wrongs any longer. The evisceration of slavery and the effect, evisceration of perennial injustices, inequalities. People can campaign on that and still prevail. That is the direction the world is moving to. Some part of the world, we as progressive lawyers will say no. The world belongs to humanity, and humanity is us. And we must be heard. And I thank the Dean and the Academy for giving me this platform to be able to share my views. I've written this in more academic banner, publications, contributed to book chapters and others, but I thought that in this, because the subject matter is wide, I should be in the position to give you some examples and to tell you what is in the world. If we have another opportunity, I may start taking subject by subject. I just wanted to give you this overview of what I understand the cost to be and what is at stake now that I'm a significant actor in the theater of operations, where these treaties and others are being implemented or argued. I thought that coming for the first time, I should be able to bring this perspective to you, and I'm prepared to answer your questions. And if you have other questions, even after you can submit to our distinguished professor and dean, I'm always ready to answer. Dean, I think my time is up, and I await your questions. Thanks so much.
Thank you, Chief Taku, for your excellent presentation highlighting the development of human rights and the serious challenges to their realization within the UN system. We look forward to having you back at the People's Academy. Thank you so much.
You're welcome. Yeah.
Roberto, would you like to begin your presentation?
Yes, Marjorie, thank you, and thank you, Chief Taku, for your remarks. The subject matter of today's session deals with the basic question of why aren't things working in terms of the fulfillment of the purposes of the UN Charter and the international obligations concerning human rights. And although things are not working both domestically and internationally, we will deal more precisely with the international side of it, and we will land in how it impacts domestically the situation. In several occasions during Chief Taku's intervention, he hinted at the problem. I mean, the question posed by the organizing committee of this session is, what are the challenges and the obstacles? And we might feel tempted sometimes to give quick answers. For instance, there's no money, which is very hard to accept when you realize that last year in 2023, the world spent $2.44 trillion in military expenditure. And then you look at the obligation and engagements in the Paris Agreement, and what we need to solve the climate crisis is 700 billion, less than a third. So is it really that there is no money, right? And then you look at the other question, there is that, well, there's the legal framework. But when you look at it, there are 9 core international human rights instruments: the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, Cultural Rights, the Convention for the Eradication of all forms of racial discrimination, the Convention for the Eradication of Discrimination against Women, the Convention against Torture, the Convention on the Rights of the Child, the Convention on Migrant Workers, the Convention against Enforced Disappearance, the Convention for the Protection of People with Disabilities. And then at regional levels, we have the African Charter of Human Rights, the American Convention of Human Rights, the European Convention of Human Rights, and the Arab Charter of Human Rights. So is it really that we don't have a legal body protecting our human rights? Well, doesn't look like. And then here is where you start moving into the grounds of what is really happening. And in order to do so, we have to understand the system from its conception, the embedded contradictions, and how these contradictions manifest in the practice. And Chief Taku pointed at it briefly. The reality of the case is that the colonialism hasn't ended. It never ended. It's like the Cold War. They never ended. They morphed, they changed form, they adapted to the times, but then the institutions didn't. For instance, Chief Taku pointed at the principle of equality among states, big and small, the principle of sovereign equality. But the charter itself doesn't respect the principle. So we have the Security Council, and we have the permanent five that are beyond good and bad, right? And which, by the way, not only they know nothing about international peace, but they will hardly push to enforce regulations like Article 26 of the Charter aimed at systematic disarmament, because the P5 are the biggest producers of weapons. And as we just said, the military industry of weapons spent $2.44 trillion last year. And it was 2.1 the year before. But then there is no money to fulfill human rights. So the system itself remains very, very racist. And some reflections of that can be seen still in the text of the Charter with the trusteeship system. So the mandate system and the trusteeship were created because, according to the view of Europe and the Americans, some countries remain savages, which they very elegantly phrase in the terms that they haven't been able to achieve self-government. Whatever the white, rich, powerful nations consider a government was, disregarding of any cultural or traditional value, which, for instance, in the case of Africa, were very important. Actually, the continent most affected by colonialism and remains affected by colonialism. Because I'm not sure that every country in the world decided to join the capitalist system as we know it today, which is a system that is enslaving everybody for the sake of 1% accumulating the 99% of the wealth, right? So in order to answer the questions posed for this specific session, you really have to dig a little bit deeper in the system itself and understand that the system itself is flawed. Because a system of international law cannot be steered by politics. And that is the fundamental problem in the system, that it's a political system. And in a political system, like the one we maintain, every country is not understanding, particularly the dominating powers, is not understanding that we live in one world where globalization has globalized everything, including the problems, like the climate crisis or the accumulation of wealth, that are problems that affect the whole international community and create transnational situations like migration. And in many of these cases, this is forced migration due to economic issues. So that there are so many political decisions of all sorts For instance, when you think about the problem of food distribution, it is very well proven that the world not only has the capacity to feed itself entirely, but we actually do produce enough food to feed everybody. Yet food can't reach the people. However, when the world wanted, or some economic powers did, we managed to bring the COVID vaccine to the last end of the world in a record time. Months. But we haven't been able in 60 years to provide people with food or water or electricity. So where are the real obstacles for the fulfillment of human rights? Because it doesn't seem to be in the structure or the apparent mechanisms or instruments. And when you look at the courts, for instance, there is this very, very strange contradiction that states become party to a treaty, so they bound themselves to abide to a law, even to join to a court like International Court of Justice, but they will not submit to the court unless they want, which is the problem of jurisdiction. Or states sign the treaty protecting human rights, but then they need an additional protocol to make that enforceable. And then they don't sign the additional protocol. So where is the problem? Because when you look deeper and you think about the existence itself of the courts and the enforcement mechanism, well, they shouldn't exist. Because the states shouldn't be violating the obligations that they willingly accepted. That's why the whole international legal system is based on the principle of consent. So what is the point of consenting to an obligation that you will not abide to? And here is when it comes to the realization that the whole problem lies in an intangible principle of international law and international relations. Actually, the core and the most important founding principle of international law and international relations is good faith. And funnily enough, you cannot enforce good faith, because then you empty of its content of good faith. I mean, you should not be forced to do something in good faith. Like that. That's quite a contradictory or questionable remark. So when we don't have that good faith, It's like we go back in time and politics reduced to real politic, which is when diplomacy fails and we resort to the last ratio, which is the use of force, which we are actually experiencing quite badly at the time. Not only there are two major conflicts going on, one with Russia, Ukraine, and then Israel and the area, but there are about 60 ongoing armed conflicts in the world right now. But in 1945, we created an organization that promised to free us from the scourge of war and promised that we were going to be able to live free from fear and want. And I was born in 1980, so I think I fall within the category of future generation. And well, we have miserably failed to achieve the objective. I mean, what was promised to me has not been delivered. And has not been delivered because some states don't want that to happen because the hegemony must remain. States, powerful states, do not want to leave their position of comfort. And it's dreadful when you actually realize how bad this embedded colonialism and position of power remains, how strong is that attachment. For instance, going back to the climate crisis, it is shocking, it might be shocking for you to realize that there are plenty technological advancements to reduce the impact. Maybe not to make it to the goal established in the Paris agreements, but to slow it quite considerable. Now, none of these inventions are profitable, and that's why they are not being implemented. So until we don't find a way to make decontamination profitable, it will not happen. And here it is. If you look at the documents from the military, conferences, manuals from the US military or NATO, even the Chinese military, they are all aware of the climate crisis and they talk about it. And they talk about it because they know that the climate crisis will create a climate migration. And you would think, okay, so they are foreseen, so they might have the interest to prevent that from happening, so there is no such migration wave. Well, no. What they are doing is they are planning how to improve their arsenal to keep the migrants away. And you can read that in statements from generals and colonels, and you can find it online from the conferences and presentations that they deliver. So they rather shoot people than stop destroying the planet. I mean, there is no legal system that can right the wrongs when the mentality of those in decision-making positions is this mentality. I think that we have been somehow a doctrine is the word, into the belief that we have evolved into democratic societies in an international democratic system. A lot of us, or a lot of the people in the world, just seems to be another gear in, the clock of the capitalist system. And it's not by our choice. I mean, we are put into a school system designed so we can be productive members of the society. What a shiny title, productive members of the society. So we can make the rich richer. That's what they are saying. And then you look at the current state of democracy, and then you look at ancient Greece, and it's not really that different. Democracy was a privilege reserved for those who could afford it. And looking at the election process in the US was, I followed the news more for entertainment purposes. People cheering for whatever somebody doesn't give a nickel is saying, just so they cheer. There is a serious problem with democracy at the international level, that if we are not able to straighten and correct in the correct way, it's gonna be too late, and it's gonna be too late because of the climate crisis. I am not sure that the end of the bipolar word in 1989, 1990 was good. And for the same reasons, and for despicable the methods, I think it has to be carefully studied whether or not we want a return of a bipolar word. Because the truth is that for 30 years, we had a unipolar word that ran as the capitalists wanted, and it didn't work. We are as unequal as ever before in history. And we haven't lived in communism for 30 years. In fact, for the past 10 years, one of the communist countries became super capitalist and it went out to the ditch. So I think we have to finally ask the question of, can we find a better system, or is there another way to manage the relation of nations in order to make it more functional? Or are we doomed to rely just on good faith and hoping that nobody resorts to the use of force again? So I don't have an answer to the question I was invited to talk about. What I have is concerns. It's questions that come from the assessment of the principles and the reality, of the assessment of the justifications on arguments given and the reality, and then to the core and the structure of the system itself. The system remains racist and colonialist. And groups of power, either military might or economic power, have these structures. And they managed to make a very, very secure system so it doesn't change unless the five of them want, which is pretty much never. So that's pretty much what I had planned for today as a contribution. As I say, I'm not answering the question. I don't know the answer, but maybe posing these perspectives and these questions will help you reach an answer. I was asked to talk very briefly, which I will do, about the right to peace, just because, as Marjorie pointed before, the right to peace became a legal reality in Costa Rica through a couple of cases that I brought before the Supreme Court of Justice when I was in law school, both. And Marjorie already summarized. One was when Costa Rica's government decided to support the coalition of the willing that invaded Iraq, an absolute contravention of the UN Charter. The other case when Oscar Arias authorized the manufacture of nuclear reactors for all purposes, including military. The history of how that right was achieved is very interesting, because it's not reduced to the case. I mean, to the specific situations that gave path to the cases. The right to peace was declared by the Supreme Court on the basis of a customary rule of what I managed the court to accept would be a customary rule of both domestic and international law. Hold on a second. Sorry about that. Sorry. So the exercise that I submitted to the court was to demonstrate that the Costa Rican people, as a people, had customarily renounced to the use of force in order to resolve disputes at both domestic and international level. And in an exercise of self-determination, the Costa Rican people decided in 1948, when Costa Rica dismantled the military, and in 1983, when Costa Rica declared permanent and perpetual neutrality, that we wanted to live in peace. So it's a collective right of third generation that was achieved by the people through a historical process that in some historical instances meant Costa Rica taking some brave decisions. For instance, when in 1983 Costa Rica declared itself neutral, the Cold War was super hot in Nicaragua. And the United States pushed with all it could the Costa Rican government to allow their contramilitaries to take the northern part of Costa Rica so they could invade Nicaragua from Nicaragua south. And despite all the threats of removals of aid and all these illegal interferences that the United States posed to Costa Rican government, decided that it was going to make the will of its people prevail, which didn't do in 2003, but the court thankfully rectified because of the action I brought to the Supreme Court. Now, it sounds in many ways as a very successful and happy story, but from my personal perspective, I sometimes wonder, why did I have to go through all that to have declared that I had the right to peace? I mean, wasn't that the promise of the UN Charter? I mean, what is the whole goal of, society itself or international law? Or what those who created the trusteeship system understood as civilization? Because if civilization is not being able to live in peace, then I do not understand what is it. And with those very quick remarks about the right to peace, Marjorie, I think I can finish my intervention.
Well, thank you so much, Roberto, for detailing the contradictions in the international legal system based on realpolitik, and posing the critical questions, and also for your brave work in the Costa Rican Supreme Court as a law student, that was so fruitful. So thank you so much. Great to have you back. Next, Marty, your turn.
Erin, will you bring up the slideshow? Oops, let's get back to the beginning. Here we go. So I'm going to go through a few slides, but before I start talking about my presentation, I'd just like to make a couple of comments about who I'm directing my comments to, especially because we've been really privileged to have perspectives from two continents other than North America. But I, of course, live in North America in the US, so I especially am directing my my slides to people in the United States, and particularly the responsibility of people in the US to look at these challenges to the realization of human rights. And anyway, so let's go next. Next slide. Okay. So what I'm going to do is a little bit different from the preceding speakers. I'm going to talk about human rights from a political economy perspective. And what that means specifically here is a rejection of the neoliberal analysis of human rights, which is all around us, and the seepage of neoliberal ideology into the entire field of international human rights, which has been going on since the 1980s. Next. So just to be clear, what I mean by political economy and a study of what it brings to the study of individual and collective human rights. What I'm going to be doing is trying to interject the elements of the exercise of power, of course, which is a political issue, by over what, such as knowledge and science, and how that determines outcomes, and looking at the role of the state and public ownership, the commons, and privatization. So that is broader than a question of the state and begins to bring in the role of capital. So one really important reason why I use political economy as a method in analyzing human rights and in talking about human rights is because it looks at whether the economy increases equality, unlike the kind of economics that we're exposed to or the analysis that we see. Because if you don't reduce inequality, you cannot realize human rights. And of course, the other speakers have talked about this. The thing is that neoliberal capitalism views inequality as natural. It rejects human rights and it rejects economic democracy. So we have to keep that in the foreground, because when we criticize what's happening, we have to realize that this is the role of the people, is to reverse this. And as we all know, human rights are to promote dignity. So that means that to realize human rights, an economy has to be organized to satisfy human needs and allow flourishing of life. And just a side note, if the issue of efficiency is at all a part of the discussion of human rights, it has to be efficiency as it supports human rights. It cannot be a separated kind of discussion. Next. The concepts we have of human rights affect how we make claims, how we advocate, and how cases are decided. The first thing I think is really important here is that using political economy allows us to critique liberalism, which is the dominant Western perspective on human rights. And it's at the focus of all the Western influenced institutions, of course, the UN institutions, of NGOs in the United States and elsewhere. And I would say that liberalism has skewed international law in many ways. Some ways that I want to mention here are that, especially this applies to people in the US and how lawyers and advocates work in the US, it has skewed the focus onto civil and political rights. It's led to ignorance and neglect of social, economic, and cultural rights. It's led to a denial of collective rights. And you can see, I give an example of a book by a former judge of the International Court of Justice, who originally is from the United Kingdom, who denies that the collective rights to peace and development even exist. Now, this is an older book, but this is very typical of the way in which much of the international legal community still views collective rights. And of course, as other speakers have mentioned, the neoliberalism rejects decolonization and eradication of neocolonialism and uses human rights to sell war. And there's a lot of evidence of that. Next. Another problem that we have with the prevalence of a neoliberal capitalism in our time is that the attempts to enforce private property interests over human rights dominates. And we need to interrogate any, quote, right to property. I'd just like to point out that in 1948, the Universal Declaration of Human Rights did articulate a right to property in Article 17, specifically individually and in association with others, and a prohibition against the arbitrary deprivation of property. However, the treaties that followed the declaration did not incorporate any article similar to Article 17. And of course, it would have shown up in the ICCPR, but it did not, because there was a strong movement against that. There is also a development in the inter-American system of the recognition of a collective right of indigenous peoples to their property, but that is seen as the traditional land and territories and the exercise of the right to self-determination, which I think is somewhat distinctive from the way that was originally formulated in the Universal Declaration. Next slide. We have, I think, getting back to basics, why do we even categorize rights as individual, group, or collective? And it can be helpful, I think, but there's a lot of false consciousness about human rights, and I think Chief Taku has done a magnificent job of educating us about the perspectives of the states that formed the African Charter about the interrelationship. But in any event, I'm going to talk a little bit about these different categories because I think it's helpful to have this background. There's especially operates in the US and maybe not so much elsewhere, but there's a lot of talk about generations of human rights. And that is often associated with a hierarchy of rights and the idea of progress. And obviously, we need to get beyond liberalism. We need a multicultural approach, and we need to reconstruct the field of human rights. And I call your attention to a book on human rights, which is the work of one of the proponents of the third world approaches to international law, and that is also a worthy project to interrogate and to learn about. So another aspect of human rights that is in many cases completely not understood by human rights activists in the US is that rights are universal, interrelated, interdependent, and indivisible. So often we see these hierarchies in this area too. But clearly a balancing of rights is required in any kind of system. And rights obviously have correlative duties. You can't have rights without duties. And I think, I'm making some of these points because I feel deficiencies in the way that human rights are approached in the US, and it may not be true in other places, but bear with me. An individual human person can claim rights of a state. So that typically the rights are claimed by individuals of the state in which they are part. And that also, this division of cultural, economic, social, civil, and political categories, as has been pointed out, was a product of the Cold War. But I think it's also a product of capitalism and what rights are going to get prioritized. I do see it useful to look at several categories of other rights besides individuals. One is group rights and the other is collective rights. So an example of group rights are rights claimed within a state. So as an ethnicity of a group of people who are subjected to racial discrimination would often be making a claim on a state. And of course, the state is required to supervise private actors. Collective rights are broader than group rights and are also a matter of a demand, a claim that's made against the or on the entire international legal system in many instances. For example, the right to peace. There's some issues, I would say, there has been mention of, for example, of the situation of migrants and the Migrant Rights Convention, but I really think that the human rights system doesn't really fully include people who are migrants, people who are not fully within a state's jurisdiction. And that is a huge problem within the system. It's also true that nations within states, that is indigenous nations, are many times in more than one state. So those are just some examples, though, of where the system itself, in the way that it adopts law and does lawmaking, is quite deficient. Next. There are a few exceptions to the general rule that all rights are equal within international human rights law regime. One is this notion that some human rights can be derogable in an emergency, and that is set out in the ICCPR in Article 4. And obviously one of the rights that is non-derogable is the inherent right to life, Article 6. People have already talked a bit about peremptory norms, that is to use Cohns, that have supremacy over other rights. But these norms are mostly about abstention. I call your attention to this book by Thirlway, who was a clerk at the International Court of Justice. Has written an interesting book on sources. Those use Cohns norms, which Chief Taku has mentioned, as well as Roberto Zamora. We have, the norms of genocide, prohibitions on genocide, slavery, racial discrimination, use of force, and torture. Obviously, we're a long way from realizing the enforcement of those norms. And other people have mentioned Barcelona Traction, which specifically refers to genocide, slavery, and racial discrimination. There's also the Nicaragua case against the U.S. for its aggression and terrorism during the war. And that is where the use of force, use Cohns norm is brought up, and then torture in the Belgium versus Senegal case. Next. So looking a little bit at individual rights, a state is obligated to respect, protect, and fulfill all human rights. So obviously this is a political duty of the states and dependent on the ability of the people in the state to control the political process. So that means regulation and enforcement of laws within the state, which govern private actors such as corporations. And it's quite obvious that the duties are both positive, such as funding, and negative, restraint. Often there's made a distinction as if that makes any real difference between whether the rights have some kind of hierarchy. It's often used with political and civil rights versus social, economic, and cultural rights. But it's quite bogus, and I'll be happy to talk about that with anybody who wants to further. So there is a provision, though, that in the Covenant on Economic, Social, and Cultural Rights that allows, quote, progressive realization of rights. And ironically, although this was adopted to relieve the economic burden on the lesser developed countries in the short term, affluent states like the United States failed to treat economic, social, and cultural rights equally with civil and political rights. In particular, the US hasn't dedicated maximum available resources for social, economic, and cultural rights as required by Article 2 of that treaty. Next. So as I said, rights are interdependent and interrelated. Here's an example of an individual right and how it's interdependent and interrelated. So the right to health, which can be conceived as a social and economic right, Article 12 of the Covenant on Economic, Social, and Cultural Rights, has a relationship to the civil right to life under Article 6 of the ICCPR, the cultural right to enjoy the benefits of science, Article 15, such as the right to have access to vaccines, and the right to equality and equity, the common article of both of the covenants. The other, point I made earlier about indivisibility of human rights, to give you more detailed example of that. The states can't accept some rights and reject others. That is just totally not acceptable as a legal matter. Oftentimes it would defeat the object and purpose of the treaty if certain articles or duties are rejected or conditions are imposed on acceptance. So I can give you an example of something the U.S. has done. It's made reservations. It makes reservations, understandings, and declarations regularly to the few human rights treaties it actually ratifies, one of which is the ICCPR. Article 20 of that treaty, which most people in the U.S. have never heard of, prohibits propaganda for war and advocacy of national, religious, racial hatred constituting incitement to discrimination, hostility, and violence. The U.S. has chosen to accept itself as for obvious reasons, I think, to this provision and to the entire article. Next. The other issue about picking and choosing principles of the rights and rejecting principles that are difficult, I deal with a lot, and that is in the area of the right to health care. So I'm going to just use an example that I have because I work with social movements and actually think that one of the ways that lawyers, law students, and people with technical training in human rights can be most effective is to help build the social movements for a human rights culture. But as far as the right to health care, which is a component of the right to health, a state is required to respect, protect, and fulfill all the principles which make that right a right, and one is universal access to all health goods, facilities, and services. Universal means everybody, not just some constituents or excluding migrants or excluding low-income people. It also means availability of health infrastructure and services. That's for everyone. You have to have hospitals and clinics. You have to have doctors. It means acceptable and dignified care. Of course, this is a point of human rights, is to improve human dignity. And acceptable means culturally acceptable, relevant to the people who are receiving care. Of course, equality and non-discrimination, which I might add, cuts across almost all the human rights principles and is always required. It also, the principle of the highest quality of care is an old principle. It's even found in the World Health Organization Charter as a founding principle. Participation refers to the ability of people to know and have the civil right to get information, also transparency, and to make decisions about the healthcare system. And accountability, of course, is the ways in which we hold our political system accountable through the courts or through other mechanisms. But these rights, so the components of individual human rights have principles that have to be followed. That's part of the way that advocates can work to ensure that their governments and government at different levels is accountable. Next. So there's also this, bringing in the economic duties of states for ensuring the realization of principles. This also means, and this is where most individual human rights advocates don't have this information and don't see this as a human rights issue, but one is the issue of a sufficient budget appropriation so that everyone can have access. So an example of how this is violated in the US is that there's smaller per capita appropriation for the Indian Health Service than for other kinds of health programs. I've mentioned that committing maximum available resources, and there's some really good work by Balakrishnan and other economists, especially around women's health issues, but have really, it's a way where advocates can question funding for war, not for fulfilling the right to health. It's also a way to question privatization because it's a diversion of funding away from actual health. And that, brings me to my last point here about, which is ever so relevant now, considering the huge upwelling in the US against health insurance companies and corporations which deny thousands of people the right to health and cause thousands of deaths daily because of the denial of health care. So, and that I just mentioned that the recommendations in the Committee for the Elimination of Racial Discrimination has talked about the need for free access. Next. Then I'm going to just mention some of the collective rights, which other people have talked about, but that are, specifically where there's been a lot more attempts to make law, the self-determination of people's right to peace, right to development, right to a clean, healthy, and sustainable environment, and just how the evolution of collective rights, I think, besides the fact that they're, generally seen as rights that evolved from the time of the UN Charter, I think actually that self-determination and the right to peace have older lineage in terms of international norms, and then say the rights to development and a healthy environment, because the right to peace, I think you could argue that it goes back to the renunciation of war as an instrument of national policy back in 1929. And in fact, even though it was, this is where they're looking at Western focused here, the 66 parties, but the fact that there is this longer history, I think, is something that we can use. Next. So thinking about collective rights, and we have so many frustrations, particularly about the rights to peace and a healthy environment at this particular moment, when we face really not only the coming greater number of catastrophes related to climate change, but also the real threat of nuclear annihilation as it's never been. I think it's difficult to talk about collective rights because they really require a kind of world system that we don't have. Obviously, they're indivisible. They belong to a group. There's no way they can be realized individually because of the need to share the benefits in order to fulfill them. It's just incomprehensible to think about the right to peace as an individual matter. And the other thing is, which if we want systemic change, which is what's required for collective rights, we have to be looking at the economic system and the national sovereignty system and the status quo. So, as well as U.S. hegemony and the corporate control that we're dealing with. So, yes, we haven't realized these rights, but in order to realize these, we need huge popular movements. I would just, point out, which other people have already mentioned, that there are so many ways in which even people who are human rights activists are kind of dissuaded from thinking about collective rights. People often get focused on individual rights or aspects of individual rights rather than collective rights because they seem so enormous to deal with. Or, the typical situation we face when we're activists is that the people in government or corporations deny that they exist, or that these are too comprehensive or vague or difficult to enforce, that they're not really rights, but just aspirations. So there's a lot of mind games that are played against proponents of collective rights that make it also difficult to build support for collective rights. Next. I think, in terms of long-term activism, and obviously we have to keep struggling, regardless of whether the system as we know it is going to exist or what we will be dealing with in the future. But I think some strategies that might be helpful are to use both individual rights that could support system change alongside collective rights. And I've been trying to think about some of these linkages, and I'm sure people also would have their own ideas based on their own activism and work. But for example, in the Universal Declaration, we have the right to an adequate standard of living, which is where the right to health came from. And that also exists in the covenant that was adopted to implement the Universal Declaration. We also have Article 25 of the Economic, Social, and Cultural Rights Covenant that protects the inherent right of all peoples to enjoy and utilize their natural wealth and resources, and the right of everyone to a social and international order in which rights and freedoms can be realized, along with the right to development. I think that trying to think of various ways in which some common problems can be parsed as part of the advocacy may be helpful. And then I just like to say that I think that, the majority of human rights activists are not us lawyers, but are advocates in many places, and who often are engaged in not only advocacy for collective rights, but also for social and economic and cultural rights. And that some of the work that we might need to do is to assist the movements to flourish in ways other than through the use of the traditional mechanisms that lawyers have of the UN system, which have not really borne us very much fruit. And one friend of mine has suggested de-judicializing human rights, which I think is an interesting challenge, because it's quite clear that you cannot achieve in the courts what you can achieve politically, and that is why I get back to this whole issue for the future of how we build a culture of human rights, and really nourish that as a collective enterprise of activists, lawyers, law students, people of goodwill who are committed to building a different system. Thank you.
Thanks, Marty, for your great analysis of how neoliberalism, that is basically capitalism, undermines human rights, and your explanation of the universality, interrelatedness, and indivisibility of human rights. And also, and I think this is a really critical point, not that all the points haven't been critical, why human rights can only be realized in conjunction with popular movements. So thank you so much for that. Much appreciated. Now we are going to have a period of time where the faculty members can react to each other's presentations, raise questions, comments, etc., and then we will open it up to questions from the registrants. So I just wanted to say a couple of things really briefly, and that is that we're talking about individual and collective rights, and I don't know of any other treaty besides the Banjul Charter, which is the African Charter on Human and People's Rights. It doesn't just say the Charter on People's Rights. I'm sorry, the Charter on Human Rights, which is what most of the treaties say. It says human and people's rights. And so right in the title, embedded in the title of the African Charter, also known as the Banjul Charter, is people's rights. And then Marty talked about how human rights also have correlative duties. And once again, there is in the inter-American system, the American Declaration on the Rights and Duties of Man, that includes women presumably as well. But it doesn't just say rights, it talks about duties as well. And listed in the American Convention are duties elucidated in that treaty, duties as well as rights. So if the faculty members would like to raise other issues, respond to each other's presentations, this would be terrific.
Who wants to be first? I'd like to bring up a common theme, which is decolonization, because I think colonization is not really part of the discourse among human rights activists in the United States. And that is something that I think is really key. And I really appreciated both your comments about the entire system of colonized international law, and wonder how, well, I feel like the people in the US need to take that seriously, and wonder if you have any thoughts about the role of US activists and lawyers, and how we could do a better job within our constraints.
Well, if I might jump, because this I feel it links with one of the rights that you mentioned, and I have some issues regarding it, which is very much under discussion currently. There is even a project of convention going on the right to development. Because I was actually a student of Mihir Kanade, who is the UN expert leading the right of development, and we, at least I argued with him, because it does sounds to me a lot like, again, colonialism. I mean, development according to who? And particularly in the case of African and Latin America and their indigenous communities, who are, and I pose this question to Professor Kanade, who disregarded it, but for instance, I don't know if it was the title in English for a movie called The Gods Must Be Crazy.
Oh, yeah.
Yeah, you know, about the Bushmen, that there is this plane and they throw a bottle of Coca-Cola, and then the bottle of Coca-Cola. Now, who are we to say that the Bushmen are uncivilized or undeveloped? I mean, they live a happy life, surrounded by the environment.
Right.
I don't know if I'd rather get eaten by a lion than eaten by cancer.
Yeah.
So, I mean, it's a very delicate issue when we are, particularly now, because the human rights discourse has been misused by some groups to promote things that are not human rights. And I'm going to give a very, very controversial example, which is the right to an abortion. For instance, let's say that I do not object to women to have an abortion and decide over their body, but I do have a problem calling it a human right, because human rights are for all humans, and I, as a man, can never have an abortion. So by default, it cannot be a human right because it doesn't belong to all humans. But it's been used, the label of human rights to give a strength to an argument, but unfortunately, what it does is that it deters the real core group of human rights. So it's one of the issues that we have to pay attention. For the rest, I just and moving a little bit to my comment, I think that the three presentations actually connected a lot. I mean, I think we all reached the bottom line that the system is fundamentally flawed because the structures and the historical moment and juncture when everything was built left us with a structure that tried to hide and disguise a structure of power that remained. And we are trying to build a just word on top of an unjust superstructure. Yeah. And I think that's where the biggest challenge comes from.
If I may say something, I firmly agree with Roberto when he says colonialism is not yet finished. In fact, it is only mutated in different forms, and more lethal and more dangerous. And also listening to what with this presentation with regard to the situation, especially with the US, about the question of the dichotomy, about the economic rights and so-called the hierarchy of norms. The founding fathers, the Africans themselves, with the African Charter, clearly saw that division within the context in which it was in the fight against colonialism. I take note the Cold War was an aggravated form of colonialism because Africans were agitating for independence. And France, which had been humiliated from the Second World War, from 1948, the very year of the Universal Declaration of Human Rights, waged war against many of African colonies. You have Portugal, you have Spain, all of them. And these African founding fathers, founding father of the African Charter, the Banjul Charter in 1966. Of course, we know what happened before then. Patrice Lumumba, Kwame Nkrumah, all of them were eliminated and killed in many ways. But from this declaration, clearly, this dichotomy was ideological, was linked to the Cold War, whatever reason the West is giving. Today, it was just an attempt to hide the reality. The Africans, they saw it as they were the primary victims, even to other communities. And this is what they said clearly again. They anchored it, they justified it about the non-divisibility on the fight against colonialism. That's what they said, reaffirming the pledge thoroughly made in Article 2 of the said charter to eradicate all forms of colonialism from Africa, to coordinate and intensify the cooperation and effort to achieve a better life for the peoples of Africa, and to promote international cooperation, having due regard to the Charter of the United Nations and Universal Declaration of Human Rights, convinced that it is henceforth essential to pay particular attention to the right to development, and that civil and political rights cannot be dissociated from economic, social, and cultural rights in their conception, as well as universality, and that the satisfaction of economic, social, and cultural rights is a guarantee for the enjoyment of civil and political rights. For the enjoyment of civil and political rights. So Africans saw that division as a means to perpetuate colonialism. They look at it within the context of the fight against colonialism, which is continuing today, because the politicization of human rights, which I think we talked about, and I think Roberto also talked about, politicization of human rights, that they've turned it upside down when you look at economic rights. They use it as a means, that dichotomy, to perpetuate colonialism, to dominate and control the world economy. And it has a serious impact on the individual and collective rights of people who are already victimized under the UN system and even before, especially the people of Africa, and perhaps in Asia and Latin America, or South America, you see.
Yeah, go ahead, Marty.
Oh, I was just going to continuing that just a little further. I think, your comments, Chief Taku, about the, use of unilateral coercive measures as a way to deny human rights, really what we see as economic warfare, right? That economic warfare, in fact, has been every bit as destabilizing to the human rights system as hot wars, when we look at the overall picture of people's situations now, and especially the rights of indigenous peoples.
I wanted to respond just briefly to a comment that Roberto made about no human right to abortion because it doesn't provide an equal right to all people. We have the Convention on the Elimination of All Forms of Discrimination Against Women, which talks about equality for all people, and particularly women. The Convention on the Rights of the Child, again, which discusses the and guarantees rights of children. The Convention on People with Disabilities, refugees, migrants, etc. And I think the right to abortion is linked very closely to the non-discrimination principle. Everyone has a right to self-determination over his or her body. Reproductive injustice impacts poor people and immigrants the most. So those are just a few thoughts that I wanted to throw out. There is a question in the Q&A, which I think is a really critical one, and I do want to preface it by saying that throughout our programs in the People's Academy, we have tried to discuss the genocide in every program and make it really a central focus. And of course, it is happening in real time. It has been going on for well over a year, and the horrificness of it just cannot be overstated. We're watching it in real time on social media in a way that has never happened before. So the question is, what are the responsibilities of U.S. taxpayers under international law to refuse to fund Israel's genocide in Gaza? And before throwing it open to the faculty, I just wanted to mention that on behalf of Palestinians and Palestinian Americans, the Center for Constitutional Rights has brought a lawsuit against President Joe Biden, Secretary of State Antony Blinken, and Secretary of Defense Lloyd Austin for complicity in genocide and failure to prevent genocide. The Merchants of Death War Crimes Tribunal, which is a symbolic tribunal I've been involved with, has charged U.S. weapons manufacturers with violations of U.S. and international law for their complicity in aggressive wars, including the genocide in Gaza. So then the question, which is a very important one that has been asked by one of our registrants, is what individual responsibilities do U.S. taxpayers have to refuse to fund Israel's genocide in Gaza? Would any of the faculty like to respond to that question?
Well, if I may say something about that, because that is it's written about. It shows a duplicity in U.S. Foreign policy and a disregard for international norms. I was in the special court for Sierra Leone. Charles Taylor was convicted on the ground that he supplied weapons to the commanders of the Revolutionary United Front for Sierra Leone, the weapons which they used to wage the war in which crimes were committed, knowing that the weapon will be used for that purpose. The prosecutors of the special court were all Americans, many of them from the Americans, former American military officers. And America clearly knows, I think, disregard for humanitarian law. But the U.S. taxpayers and this conflating outright criminality of giving of weapons of mass destruction to bombard and kill people and commit international crimes and support for Israel, the fact that they cannot make that distinction. They should be supporting Israel or any country for that matter for respecting the international rule of law. I said, and I said it many times again, that in modern warfare, and America should know this better, they should be able to make a distinction between Hamas and Palestinian civilians. That attack is against Palestinian civilians, men and women, but it is an attack against humanity. America is trying to set another standard for the rest of the world. And I think the fact that American taxpayers, American politicians, they cannot even question this. They cannot even condemn this. On the contrary, the weapon, the money used, the sheer amount of money used to deliver these weapons was enough to bring about peace. And it showed that there's a two-state solution that respects the rights of Palestinians and perhaps also the security of Israel for them to live as neighbors in that particular place. But I think without this support, these weapons supplied by American taxpayers, maybe there will be the solution. They are keeping that conflict alive. And I think that's outright complicity. I'm not going to say it's America as such. We should be able to know international law, especially international criminal law, what we call superior responsibility and individual criminal responsibility of superiors, that the people themselves making the decisions, they are complicit. They should not try to hide behind the shade of sovereignty or the national flag in order to support this criminal policy that is actually undermining the conscience of humanity and destroying the very basis. Take note, the first convention was the Genocide Convention 1949. And you just said something. After the Universal Declaration of Human Rights, the next convention was about women. It was about women before they even went for the other human rights in 1950, about the convention of women. So it had been very, very slow because the people who were involved, they put the superpowers on the convention. That's why it didn't come out the way it was. So I can rightly say that it should be a matter of grave concern that humanity, human life is losing its value on the watch of America, caused by America. That has professed itself to be a beacon of civilization or democracy. I think for me, I feel very, very passionately about that. It is not about Israel It's not about the Jewish people. It's not about the American government. It's about a group of individuals, both in Israel and the United States, who are belligerent, committing genocide. And I think I totally oppose, and I've said that in many instances. I've written about that.
Yeah, Marjorie, to respond directly to the question, I hardly see personal responsibility or liability for a taxpayer for several reasons. The first one is that, in principle, funding is a voluntary activity, and tax paying isn't voluntary, as we all unfortunately know. Then the person is subject to a relationship of power under the sovereign powers of the state. And then the person cannot not follow a legal obligation. And then the third element is that unless you have a specific tax to specifically fund a specific act, tax come into a bucket, and then they mix, and then from the bucket, they make the budget. So you don't know where your money went. You cannot say, okay, my money, the $5,000 I paid in taxes went to these funding, because you don't know where your money goes. So I can hardly see any international responsibility for a taxpayer abiding to the obligations imposed on this person by the state.
Yeah, during the Vietnam War, there was a mass movement for people not to pay their taxes because they were partially funding the war in Vietnam. And I don't know that that was terribly successful. There's an interrelated issue, and that is U.S. service members under the Uniform Code of Military Justice and the Army Field Manual. They have a duty to obey lawful orders. They also have a duty to disobey unlawful orders. And there are many people who are refusing orders to do things and deploy to places that could be supportive of Israel's genocide. I also, before we want to run out of time, there were a couple of other questions.
Can I just comment on that too?
Yes.
Oh, because I think there's an ethical duty perhaps here that applies to taxpayers that is distinguishable from the legal duties that governmental officials have, who are responsible for authorizing and implementing the provision of weapons to Israel and the otherwise enabling of genocide. And then there is also a question about what the duties might be to prevent genocide, which I think is a bigger question for us to continue discussing.
Right. Thank you for that. Roberto, there's a question posed to you about suggestions you might have for legal strategies in the United States to combat support for genocide. And Marty, a question addressed to you: how do we get people's movements to recognize the treaties that protect collective rights and economic, social, and cultural rights? And I want to put in a plug for the People's Academy of International Law, because that is one of the primary focuses that we are aiming for. So either Marty or Roberto, if you'd like to respond to those questions.
Do you want to go first?
Ladies first.
Okay. I think actually using the principles of the treaties as ways to help organize and to embed those principles in the work of organizations. For example, the principle of universality. I use universal access, for example, with health, with healthcare. There's also the general principles of non-discrimination and equity. And unfortunately, the US government weaponizes those principles all the time. So what needs to be done is to actually explain, is to use those in a different way to really turn people's minds towards what the real requirements are to comply with international human rights law. So I think deconstructing the treaties in ways that are popular so that people can understand based on the particular principles, whether it's the right to peace or it's the right to education, can help to bring an understanding of what in reality that would mean, and also using that as a way to hold corporations and electeds responsible by actually measuring how that principle is upheld or not upheld.
It's a great question that I have received a considerable amount of times as what can I recommend? And it's very hard because the systems in the United States and in Costa Rica are quite different, beginning with the fact that Costa Rica has a full monist system. And what I'm saying with this is that in Costa Rica, you apply international law as if it was domestic law, because international law is considered part. I mean, there are no international and domestic law. We have law, and that allowed, plus the existence of recourse, direct recourse to the Supreme Court, is what allowed me to file the case. Now, to win the case is a different story, because, although I strongly believe that on the grounds and the merits, in any case, I should have won the case. If a giraffe would have filed the case, it would have won it. Because the case related to a very deeply intricate value of supreme importance for Costa Rica society. So, for instance, and the number, for as crazy as it might sound, is real. So the day President Pacheco issued support to the coalition of the willing, they ran a poll on what was the people's opinion on Costa Rica's support in the coalition of the willing. And 99.2% of the Costa Rican people said, no, we are absolutely, completely against that. So if we understand that in principle, the government is an expression of the will of the people, that in many cases doesn't really happen. But in this particular case, it did happen. So the question is, what kind of society underlies the structures in the United States? Is at any extent society proclived to overpowering? And in many ways it is. I mean, I'm not saying a genocidal society, but overpowering, that thing that we have to be bigger, stronger, and faster, that American, very American motto, bigger, stronger, and faster. So one thing that has to be addressed is the core values of American society. It's a very diverse society, but it's also becoming a very polarized society. You know, there is the right wing gun bearer group growing bigger and stronger. I don't know if faster, but bigger and stronger. And then the left is also radicalizing in its own very way, which means that both sides are becoming more violent. So that's at the societal level. Then at the political level, I think that the United States is facing the same problem that many bipartisan societies are facing, that they are doomed to choose between a cancer in the left lung and a cancer in the right lung. But there is no real option. I mean, I wasn't happy with neither of the candidates in this election or the last election or the previous election. And I think that's a problem that many democracies are facing at the moment, and which is what is polarizing things. Because we talk about the freedom to choose and the freedom to choose, and that works great when we are talking about economy. But when we're talking about democracy, I mean, you go to the supermarket, you have 27 kinds of cereal. You go to the ballot, you have 2 options. You know, it's not really much a right to choose there. So the answer to the question again is very, very deep, and I think it has to do both with societal issues to resolve in terms of core values and with structural problems, because democracy has become the random exercise every 4 years where you choosing to 2 options that are equally bad.
Yeah, I think for me, I think Roberto said something about the past 30 years. We had just, the world was one dominant power. And what did America do with this unique position it found itself as a sole world superpower? I think looking at the floated many ideologies about isolationism, or in other words, whether how America confronts, how America reacts to the world of technology, to the world of changing climate, climate change, to the different forces in the world. The way America responds is depends solely on the institutions of democracy that were empowered from the founding fathers of America, the Constitution, and their Constitution, and in particular the judiciary in America that has become a tool of ideological, to protect core ideology under the pretext of either say the conservatives, liberals, and things. Those have become labels, pure labels. But the hard core is that the gains that they had under the civil rights movement have been eviscerated. And now America was on the conquest of the world, but back in America, a small core group of individuals playing on the fears and emotion of people, the gains of the civil rights movement, people who had gone underground, the progressive movement, they have been empowered, using them through this coalition that have come up for them to attend to control the world capital, the resources of the world, control science, control the way the world works, in fact, to set up some form of alternative world governance along ideological lines. And that is the risk because this group of people were never there for the common people, for the economic interests of anyone. They were just there for themselves and their power. And they have now a legal structure, architecture in place that enables this and supports this. And I think the debate now should be about, the bigger debate is that, what direction is America going? A century from now, will America still be a superpower, or will go the way the Roman Empire went? I'm very worried. As a superpower, America should be there to be a coalition with the rest of the world, for the world's people, for the economic prosperity and peace in the world. But this is not where this small group of people, profiteers, who want to take power and dominate the world, no longer the governance of American people and for the people, government for the people, and by the people for America, but for themselves. And I think that's where even the debate within America, I don't know whether they themselves, the ordinary Americans who put them in place, who have supported this system all along, I don't know whether they themselves have an answer, or they are conscious about the direction in which they are leading the U.S. with regard to economic, social, and cultural rights.
Well, we have our work cut out for us, and I want to thank Chief Taku, Roberto, Marty, also Aaron, our administrator, and the interpreters for your participation in this course and making it a success. Our next program, the next program of the People's Academy of International Law, will take place on Thursday, January 16th at 9 o'clock a.m. Pacific, 12 o'clock p.m. Eastern, and it will be Seminar D, The Crisis of Public International Law, the Case of Palestine, and Impunity for Genocide. And the faculty for that course includes Raji Surani, Francesca Albanese, Maria LaHood, and Shad Hamouri. So thank you all so much for attending, and we will see you in January.
Thank you.